Good afternoon, everybody. I am Surya Pratap, third year of BLLB Honors course at Galgodias University, and my presentation topic is trademark. So, I am going to speak for a few minutes on the topic that is trademark. So, starting with the historical background of trademark. So let us discuss what we have to discuss in this. So starting with the intellectual property right, and we will discuss what is trademark and historical background and characteristic, classification, registration procedure, and fees and form benefits of trademark. And at the end, we will discuss the cases related to the trademark. So starting with the historical background, so India borrowed the British Trademark Act 1938 and prepared the first act on the subject as Trademark Act 1940. So the act is now operative as Trademark Act 1999, which come into force with the effect of 30th day of December 1919. So, intellectual property is the property that arises from the human intellect, like anything which is any inventions by any individual or any firm needs protection so that it cannot be get used who is not authorized to use it. For that, this trademark is introduced to us. So everybody has the a trademark on their work. So IPR are the statutory right and allows the creator and owners of the intellectual property to exclude other from exploiting the same commercial for a given period of time. And the subject matter is the trademark is given to provide a legal protection to the marks of trade like brand names, signs, symbols, etc. And for examples are like Amazon and Adidas have both word mark and the device mark, which is logo as well. And the difference between trademark and other IPRs is that trademark is given for an indefinite time, and it may be renewable in after the duration of 10 years. So discussing about the IPR, we have classes of IPR, which are patents, copyright, and trademark. So starting with the patent. Patent it is for inventions like new process, product, technology. As I have uh, says earlier that uh, inventions which is made by any scientist, any in technical field or any biological field or any. So to protect that, the patent law has came, and it is a contract between the inventor and the government, which is patent office. And the second one is copyright. Copyright means it is a creator of literary, dramatic, musical, artistic work, cinematograph, film, and sound recording as well. An exclusive legal right guaranteed to the creator's original work for use and distribution. So, according to Section 2 ZB of Trademark Act 1999, the provision says that trademark means a mark capable of being represented graphically and which is capable of distinguishing the one good from the other goods and one services from the other services. Uh, and person from other and may include shape of goods, their packaging, and combination of color. Combination of color, the example is we have in daily uses like uh, mm, dairy milk wrapper, which is purple in color. So and we have last one is a trademark. So, as I already mentioned that it is defined in section 2 ZB of the Act. So, all and also trademark is typically a name, word, phrase, logo, symbol, design, image, sound, and combination of these elements. This is also a range of non-conventional trademark comprising Marks which do not fall into these standard categories may therefore be visible sign, color, shapes, moving images, hologram position, or non-visible signs as well, like sounds, scents, taste, lecture, and this this is basically including as non-visible things. And types of trademark, we have many types of trademark, as we have a word trademark which includes only word, like for example we have the coca-cola, uh, and device mark, which includes both the word and the logo, like adidas. And we have a service mark which includes service only, not goods. And we have collective marks used to by group of companies, like we have a example which we have used already, like Sony. The brand Sony make a mobile like Bravia and Xperia both, so it is considered to be the collective mark. And the we have certification marks which is used to define a standard, well-known marks which is very much popular in the large population of group. And unconventional trademark, like unconventional trademark includes many, like color and sound includes any ringtone of any particular phone, like we are using any mobile phone like Nokia, and when we switch off and then again switch on the phone, then we have that particular sound which opens, which we hear during the time of opening. So that is a particular sound which is considered to be the trademark of Nokia. And also shapes includes like 2D and 3D, like bottle shape, and many more. And smell, this smell is not considered in India, and it is considered in USA. Like tennis ball in USA have a particular have a particular uh, mm, like have a particular smell which we do not get in other balls, tennis ball that was. And trademark can be owned by any individual or any companies, as I have already told. It can be of any firm also, companies, or any individual particular person, and should be registered at the governmental agency, which is usually referred to as the trademark office. When a trademark is used in a connection with services, it is sometimes referred to as a service mark. As I have told that service mark is one kind of a trademark. The main purpose of trademark is to identify the source of a product and distinguish that product from the product coming from other sources. Like in section 2 ZB of the act already says that mm, uh, the main purpose of this uh, trademark is to differentiate the product, the original and the duplicate product, so that no confusion take place during the recognition of original and the fake product. Yes, we have we have listened and we have seen many times on any product. It is on over the name of any product. It is written TMSMR. We will understand here, like any trademark which is unregistered. That is a mark used to promote or brands goods. Any mark which is unregistered, uh, so it is used as a TM. And for the unregistered services, it is SM. And for the registered, we have an example of registered trademark. It is McDonald's. So we can see and recognize that whether it is registered or it is not registered services or any goods. For the goods it is written over their TM, and for the services it is written over their SM. And any trademark which is registered by following all the procedure given under section 18 to 23 is uh, there we will see it will be written as R, capital R, as shown in the slides. And moving forward, we have the Indian trademark law. Indian trademark law provides protection to a trademark statutory under the Trademark Act 1999. And for the protection of the trademark, we have to get the registration done by the register office. And register office, like trademark are the protected by intellectual property right, will be protected through the registration under the section 18 to 23. And let us discuss the provision which deals with the registration of the trademark. So provision start with section 18, which is application for registration. Single application for different categories. If registrar refuses the application, he will record reason. And in section 19, the registrar may reject the application after being accepted. If falsely, if any in confusion, if he has registered that application, he has the right to reject in under section 19. And under section 20, advertisement of application, he will do the advertisement so that if anyone has objection can file it. And section 21, opposition to registration within a 3 month of date of advertisement. Here in section 21 it gives one chance of duration, that is of 3 months, so that if anyone getting an objection can register for that. If anybody has on that goods already have the trademark. And section 22 deals with the correction and amendments of the application. If any names are written wrong or anything else, so we can do the registration, we can do the correction or amendment of that application. And at the last, after following all the procedure, if get successfully, then our trademark get registered under section 23 by the registrar office. And in 2010 amendment 36A to 36G have been added for protection of trademark through international registration under Madrid protocol. So statutory protection trademark is administered by the Controller General of Patent, Design and Trademark, a government agency which reports to the Department of Industrial Policy and Promotion under the Ministry of Commerce and Industry. The law of trademark deals with the mechanism of registration, protection of trademark, prevention of fraudulent trademark. And the law also provides the right acquired by registration of trademark, modes of trademark and assignment of the right, nature of infringement, like infringement. There are many remedies provided in two form, like one is civil and in like criminal. And in both the infringement there are different kinds of penalties, punishment, penalties for such infringement, as I told already. And let us discuss the scopes of rights. Scopes of right of exclusive use, right to assign. Exclusive means if you get under section 28, it deals with the it tell us about our trademark, we can have the exclusive right over it. And right to assign means we can transfer it under section 38 of the provision of the act. It give us right to transfer our trademark to anybody else. Suppose that I am Surya Pratap, I can take a trademark of SP and I can also transfer it to anybody else. Similarly, like Sachin Ramesh Tendulkar, a famous cricketer, has taken his trademark on his name, like SRT, that is Sachin Ramesh Tendulkar. And same like we have Akshay Kumar, who has taken a trademark on Khiladi Akshay. And we have one famous personality, that is Shahrukh Khan. he has taken the trademark on his name like SRK. He has taken because so many dramas institute taking using his name for the commerce purpose, for the benefit purpose. That is why he has taken so that no can make a fraudulent use of it. And coming over, we are discussing scope of right. Then the third which I am going to tell is right to seek legal remedies against the infringement. If anyone is getting infringing your right, then you can claim for that, and he will get the punishment. And the last one is the right to seek correction of registrar, section 28, regarding name and address, etc. And and we have a provision, section 29 of the act, which talks about the trademark is infringed. If your trademark is infringed, then when a person using is not authorized to use the trademark, or using the registered trademark after making little alteration or addition to it, like using the brand name Adidas, it is a duplicate of Adidas, little alteration between the name. So the infringing trademark must be written, printed, etc. Oral use is not infringed. And the one most essential element of the infringement is that trademark must be in the written or printed form, and not allowed in the form of oral. And section 30 talks about if the trademark is not infringed, when you will uh, what you have, what anything has been done will not considered as a infringement of the trademark. That is use not making unfair or advantages. So if you are using a trademark of something, you can take it, your purpose has to be for the good purpose, not for unfair advantages. You have to use for the fair. It must be fair, like you are promoting anything, uh, then use it for the promotion only, not for your commercial benefit. the the line want to say only this. And the honest, like honest practices in industrial or commercial matters, use of trademark must for identifying a goods or services. Like anybody have a shop of Adidas showroom, then he can use the name of Adidas in uh, front of his shop, so that everybody can get that, yeah, this is a shop of Adidas, having a showroom of Adidas, and we will get a product like Adidas. So that is for the fair advantage, fair purpose, using it for the fair purposes. So coming forward, we have a characteristic of trademark, that is distinctive and descriptive. Preferably be an invented word, easy to pronounce and remember. It should not be very much complicated to speak or pronounce, so that everybody can get used to speak. Easy to spell and write legibly. And short, it must be in short form, not very big name, so everybody get forget. mm, like appeal to eyes as well as ear, must you can hear it and see also. And satisfy the requirement of registration, not belong to the class of mark prohibited for registration. And coming forward, we have the concept of passing offs and infringement. See, when you have a registered trademark, then then it will be, if it is violated by somebody else, then it will be considered to be the infringement. And um, if your product is not um, not registered for the trademark, then the action will be again of the passing off. Passing off is the protection to unregistered goods and services. And in passing off, plaintiff has to show the proof that he was registered for the same, and it has been violated by somebody else who is not authorized to use of it. If trademark is unregistered, then the action is of passing off, as I have told already. Similarly, the essential element of passing off, it must be number one, reputation, number two, misrepresentation, and number three, which is legal damage. Must be legal damage, must make some commerce, um, like economically loss. And here we have one slide which deals with necessary to register a trademark. Yes, it is very necessary to register your trademark uh, for secure it from fraudulent use or unfair advantages, or by you any if any person is using it who is unauthorized to use it. To protect it, we have to register our trademark, and the provision is given under deals with section 18 to 23 of the Trademark Act 1999, which deals with uh, which which give us procedure to apply for the application and get registered or trademark. And here registration of trademark is not compulsory. However, registered trademark have additional benefit when compared to unregistered trademark. Registration of trademark allows the owner of the trademark to file infringement suit for the violation of his right already discussed, um, whereas the unregistered user has to search remedies in common laws. Mm, like we have the exceptions. Sometimes we can use the trademark that is only for the purpose of fair use. Nominative fair use is an exception to the right of exclusive use of the trademark under the Trademark Act 1999. And who may apply for the registered? Any person claiming to be the proprietor of the trademark used to proposed to be used by him can apply. The application may be made in the name of an individual partner of a firm, a corporation, any government department, trust, or joint application. Mm, Here registration procedure, uh, same application has to be filed in the section 18, and 19 says that the it may be rejected by the registrar, and 20 says that advertisement of the application, and 21 says that opposition to registration, any objection within the 3 month date of the advertisement, and 22 says that correction and amendment of the application, and 23 last says that registration, which will be done after following all the procedure. And trademark search, talking about, first step is determining the uniqueness of your mark, without which there may be greater risk of being sued for trademark infringement. That is why they give, when suppose that when we are going to take a trademark, then they give us TM, not they directly don't give us registered R, they give us TM. And for after 2 year they investigated whether it has been already registered or not. uh, that is why they give a 2 year, so that uh, no fraudulent take place. Mm. And after that, if no objection take place on the same trademark, then they will give you the proper R sign. Rejection of your trademark application, third party challenging your trademark. And terms and duration of the trademark, as already discussed, registration of trademark is of 10 year but may be renewed subject to the payment of the prescribed fees in accordance with the provision of the Trademark Act 1999. An application for renewable of a trademark can be filed within 6 months for constituency body of expiry of the last registration of trademark. And we have the benefits of trademark, that when if we have a registered trademark, then no one can uh, get unfair use of it. And if anyone is doing that, found doing that, then he will sued by us, in a court. Increases the company brand image in the market. Other companies will not be able to register similar trademark. Help the company in case of domain name dispute. Gives greater credibility to the company. Allows the company to stop other from using marks that is similar to the trademark, because a part of company violation as intellectual property assets. Allow the company to sue any party for infringement and claim compensation. Talking about trademark infringement is a violation of exclusive right, which is provided under section 28 after we get our registration done. Attaching to a trademark without the authorization of the trademark owner or any licenses. Trademark registration Trademark infringement mostly occurs when a person uses a trademark which may be either a symbol or a design which resembles to the product owned by the party. The trademark owner may begin a legal proceeding against a party which infringes its registration. Its registration and offenses shall be punishable with imprisonment for a term of minimum of 6 months, but which may extend to 3 years, and with a minimum fine of 50,000 rupees, but which may extend to 2 lakh rupees or more. Under the Trademark Act, a person infringes a registered trademark if the person uses a trademark, a sign which is substantially identical with or deceptively similar to the registration trademark or good or services covered by the trademark registration. So at the end, I'm summing up with the case that is Amul wins trademark case in Gujarat High Court, September 24, 2007. Amul has won the trademark cases in Gujarat High Court and no one else can use it. The Kaira District Cooperative Milk Procedure United Limited and GCMMF had filed trademark infringement cases against two local shop owner Amul Chasmagar and its partner Amul Cut Peace store in the District Court Anand. The District Court Anand passed an order dated 25 April 2007 ruling that it has a clear case of infringement and restrained the two from using a Amul trademark, that is Amul trademark. Amul Chasmaghar had a challenging that this interim injunction, that is temporarily injunction in the Gujarat High Court. The Gujarat High Court ruled the decision in favor of Amul, term, terming the order passed by the trial court as true, correct, legal, and in consonance with the fact of the case as well as in accordance with the provision of the Trademark Act 1999. So basically, I'm done with. Thank you so much.